introduce yourself for the record.
Thank you. My name is Marna Anderson, and I am the Executive Director of WATCH. We are a volunteer-based court monitoring and research organization operating in Hennepin County, and we've been monitoring Hennepin County Court since 1993. Our mission is to make the justice system more effective and responsive on cases of violence, particularly against women and children, and to create a more informed and involved public. In addition to operating in Minnesota, we had, like many great ideas that have started in Minnesota, we export our model to other states, and so we're a model in that way as well. I'm going to just take a few minutes to talk a little bit about our monitor's observations, because even though I believe gender discrimination is less blatant now than it was when we started monitoring 16 years ago, we still observe evidence of gender discrimination in the courts. I would say in most of it's related to underlying cultural beliefs. So for example, beliefs that women make up stories of abuse or rape to get a leg up on a divorce, to get back at their boyfriend or husband, or to have for financial gain. So even though national statistics indicate that false accusations of domestic violence and rape are as rare as they are as other types of crime, about 2%, women often find themselves face to face with this belief when they confront the justice system. And that comes out mostly in comments made by attorneys and judges and also jurors' decisions. And I'm just going to read 3 examples for you that our monitors have gathered over the last couple of years. A judge suggests to a petitioner in an order for protection proceeding that a divorce could lead to her financial ruin, and he quips, "You may end up joining the circus and living in a tent." It's not exactly what you want to hear when you're going for legal protection from your abuser. A jury acquits a defendant accused of second-degree assault for strangling his girlfriend until she passed out. The prosecution had medical evidence, eyewitnesses, a 911 tape, and a defendant's admission to the victim's teen daughter at the scene. But this was not enough for the jury, who said to the prosecutor after the case ended that they believed the victim, quote, exaggerated the assault because she saw her meal ticket walking out the door. A judge denies an order for protection, a request for an order for protection, stating that he believed the relationship was, quote, full of jealousy and animosity, and that the drama was being played out in a domestic violence court proceeding. This petition also described a strangulation assault that was being heard in the criminal courts. Perhaps one of the most obvious examples of gender discrimination in the courts is in the child protection cases, where WATCH recently completed an 18-month-long monitoring project. Females were the subjects of 93% of the child protection petitions in the cases we monitored in Hennepin County, 93%. This is partly because women are more frequently the custodial parents, the primary caregivers, but partly because of increased scrutiny of women who seek public services such as subsidized housing and economic assistance. Approximately 85% of the reports that are made to child protection are made by mandated reporters, doctors, teachers, and social workers. In short, women are more frequently the subjects of child protection investigations because they face greater economic disadvantages than men do. And in child protection proceedings involving domestic violence, which tends to be, research shows, about 30 to 50% of the child protection cases, there is also, the mother is also being battered. Frequently, the assaults do not result in charges or arrests against the violent abuser. Instead, the children are temporarily removed from their mother's care until she can prove to the courts that she is capable of protecting her children from the abuser. So the criminal case goes away, the abuser is not held accountable, and the mother is left to pick up the pieces and try to jump through all of the case plan work that the courts is asking her to do so she can eventually get her children back. In one of the cases WATCH monitored, the mother, who suffered from depression and addiction, was only allowed supervised visits with her children. In contrast, the father of one of her children, who is a convicted sex offender, was allowed unsupervised visits. The reason she was not allowed unsupervised visits is because she was not attending her support groups at one of the advocacy organizations. But I do want to leave you with some good news, and it's this. We also gather a lot of evidence in the courts that I believe supports the notion that changing the laws changes attitudes. And there's examples of ways in which the justice system, because it does act swiftly and appropriately in many of these types of cases, it changes attitudes of family members of victims, and we've seen that in the courts. So I want to read one example to you. During a sentencing, the victim stated that her relationship with the defendant had grown stronger, and she believed the violence wouldn't happen again. Afterward, the judge addressed the defendant saying, "However forgiving your girlfriend will be if this happens again, the court system will not. A man abusing a woman will simply not be tolerated, and the court takes domestic abuse very seriously." A constitutional amendment for equality provides an opportunity to keep moving down this path where the justice system is sometimes, and in some ways, ahead of societal beliefs. And I think you have the opportunity, we have the opportunity to explicitly make equality a firm principle of law and solidify women's equality and hope and eventually create a less biased justice system. Thank you.
Thank you. Any questions for this witness?